Ladies and gentlemen, I would like to welcome everyone at the webinar dedicated to the topic that could not be more timely, important, and necessary: the establishment of the Special Tribunal for the crime of aggression against Ukraine. Unfortunately, the aggression by the Russian Federation escalates yet more and more. Missiles and Iranian drones continue hitting civil infrastructure and destroying residential buildings in Kiev, Lviv, Kharkiv, Ivano-Frankivsk, Dnipro, and so many other cities. They continue killing pregnant women and children and cause shortages of electricity and heating in Ukrainian homes just as the winter comes. Except for the military response, the only mechanism that is able to stop this horror is the mechanism of accountability under the international law. The Special Tribunal is an integral and irreplaceable part of this mechanism. It would send a clear signal that justice will be served and will strip President Putin of his status, influence, and support. When experts, professional community, and civil society were urging world leaders to create the tribunal back in March, most of our addresses remained skeptical. However, now the European Parliament, Council of Europe, NATO, governments of European countries urge the establishment of the Special Tribunal for the crime of aggression. In fact, just yesterday, the Parliament of the Netherlands voted in support of the tribunal, thus making us one step closer to its establishment. It all became possible only due to the united policy and stance of the state authorities of Ukraine and civil society. We are glad that today, Member of Parliament, Alexandra Kuchura, is here with us. Unfortunately, Mr. Yuri Belousev, the head of the War Department of the General Prosecutor Office, could not join us due to the urgent circumstances, but I would like to nevertheless acknowledge the outstanding role of all state authorities involved: the Office of President, the Minister of Foreign Affairs, the Ambassador Koronevich, and the Prosecutor General. We are very grateful that the international support started from our good partner, the New York State Bar Association. NISBA became the first international legal association that urged the United Nations General Assembly to empower the Secretary General to establish the tribunal. I would like to sincerely thank President Sherry Wallach, Scott Carson, Aziz Filabe, Ed Lancey, Sergei Hoshovsky, and all of the NISBA team. And in trampling the road towards the tribunal, we rely on the knowledge and expertise of the Global Accountability Network and its founder, Professor David Crane, who is founder and chief prosecutor of UN Court on Sierra Leone. We are grateful to Professor Crane and his team for being among the first experts in the world to raise the necessity of the tribunal and for further support in fighting for what we believe is right. So I would like to thank our honorable speakers, Professor David Crane, Ambassador Hans Corell, Ambassador David Schaffer, Professor Jennifer Trehan, Professor Irwin Kotler, and our moderator, Professor Milana Stereo, for making our voice louder. And I'm sure that the ideas and discussions shared today will make our goal closer. So at this, I would like to invite to the floor my friend, Ms. Sherry Wallach, the president of the New York State Bar Association. Sherry, please, the floor is yours.
Thank you so much, Anna. This is wonderful to be here, unfortunately, under these circumstances, but I am thrilled to be able to form these partnerships with the Ukrainian Bar Association and the Ukrainian legal community in an effort to uphold the rule of law and to ensure that those are held accountable for their illegal actions. As Anna mentioned, I am the president of the New York State Bar Association. The New York State Bar Association stands by the people of Ukraine, and we strongly condemn the Russian Federation's invasion of the nation of Ukraine. This act of unwarranted military aggression against a sovereign state is a flagrant violation of the United Nations Charter, Helsinki Accords, and established norms and principles of international law. Last December, members of our international section, led by then Chair Ed Lenski, prepared for the possibility of an incursion into Ukraine by Russian forces. They opened a section chapter in Ukraine and worked by developing a memorandum of understanding with the Ukraine Bar Association. The chair and chair-elect of our Women in the Law section and liaisons from our Young Lawyers section joined the section in these efforts. When the invasion occurred on February 24th, we had a plan. Led by international section members, our association reached out to the chapters, the Memorandum of Understanding partners, and bar associations across the country and around the world. We urged them to issue similar statements condemning the Russian assault and to join us in coordinated effort to support and assist the independent nation of Ukraine. Together with our partners in the international community, the New York State Bar Association demanded that the Russian Federation immediately withdraw its armed forces from Ukraine and restore Ukraine's territorial integrity and international borders. To provide much needed support for the legal profession in Ukraine, we developed an initiative whereby foreign lawyers could join the Ukrainian Bar Association to provide financial support for the association and to pay the dues of lawyers whose income had been cut off because of the war. The international section's Ukraine task force set up teams to work on specific issues. It established a network of international lawyers and aid agencies to collect evidence of war crimes, address sanctions, do much needed fundraising, and to assist those displaced by the fighting. As the plight of displaced people became more dire, the Ukraine Task Force's immigration team developed a volunteer nationwide coalition to help those in need. The task force created a website with information about immigrating to the United States for Ukrainians fleeing the war and US citizens who wanted to help them. Our association has taken a series of other practical steps as we strive to give whatever aid and comfort we can during this incredibly difficult and challenging time for the people of Ukraine. By sharing resources with the lawyers and aid workers throughout Eastern Europe who are working tirelessly to help alleviate the crisis, by training hundreds of our members to help Ukrainian refugees, and holding seminars for lawyers on how to gain US temporary protected status for refugees, and by passing a resolution before our association and bringing it to the American Bar Association, where it passed before their association, a resolution that urged the United Nations to develop a tribunal or other body to address and hear the allegations of war crime of aggression. This is necessary and vital work. We must help people in the now, but we must also look to secure the future. The crime of aggression, the war crime of aggression, cannot be left unaddressed. It cannot be left forgotten. We must demand accountability for this invasion. The essence of living in a functioning democratic society governed by the rule of law is that no one is above the law. The United Nations Commission of Inquiry on Ukraine has found evidence of war crimes and violations of human rights and international humanitarian law. We have urged the United Nations to form an international tribunal to prosecute the crime of aggression against Ukraine. We understand there are roadblocks to the creation of the tribunal, but those must be overcome. Central to the mission and purpose of our association is our vow to uphold the rule of law. The rule of law means that law is applied equally to all without fear or favor. This is a foundation of a democratic government. We work to uphold the rule of law at home and internationally. We strongly condemn the violations of the rule of law everywhere. And as an association, we have taken a very public and vocal stand condemning the Russian Federation's aggression and urging the international community and our own nation to maintain pressure on the Russian Federation and its allies. And we will continue to do so. No one can be above the rule of law. It must prevail. Our international order depends on that. There is no more important mission. And I wish all of you the best in your fight and in your day-to-day struggles, and to your families and to your loved ones and friends. And we are here behind you the whole way.
Thank you. Thank you, Sherry. You know, we are strong together. So once again, thanks for your support and thanks for your devotion for the restoration rule of law in Ukraine. Our next speaker is Ambassador Anton Kirinevich, the key person from the government of Ukraine who does tremendous work in advocating the establishment of the tribunal at the international arena, but he could not be with us today. However, he kindly recorded an address which I now would like you to watch. Please, Katerina, could you? Thank you.
Address you during this very much important online event on the establishment of the Special Tribunal for the crime of aggression against Ukraine. I would, of course, be very much happy to be present with you on this event, but due to some pre-scheduled meetings in Germany, in Berlin, I have to be there. But notwithstanding this fact, I send my big words of gratitude, and I'm really thankful to the organizers, to the Ukrainian Bar Association, and to other colleagues and other organizations who organize this event and who support the idea of the establishment of the Special Tribunal for the crime of aggression against Ukraine. I'm also really grateful to Ukrainian Bar Association, to the Ukrainian Expert Legal Society for open public support concerning the accountability to secure the responsibility for the crime of aggression against Ukraine, and the open public position concerning the establishment of the Special Tribunal for the crime of aggression against Ukraine, and the relevant public statements and addresses to our international partners, in particular national parliaments of foreign states. This is really very much appreciated. So, of course, as you know, Ukraine tries to use each and every possible international legal instrument and mechanism to wage lawfare against the Russian Federation. Since the Russian Federation wages warfare on the battlefield and on the battleground and decided to use this mechanism in order to fight with us, we are trying to use all the possible international legal tools to bring Russia to responsibility for all its violations of international law committed either by Russia as a state or by citizens, nationals of the Russian Federation. We call this process lawfare. And Ukraine vastly, effectively, and actively uses all the possible international courts and tribunals since 2014, since the very start of the Russian aggression against Ukraine, in order to bring Russia to responsibility. We have made applications to the International Court of Justice, interstate applications to the European Court of Human Rights. We use the mechanisms of International Tribunal for the Law of the Sea and of the tribunals under the United Nations Convention on the Law of the Sea. Ukrainian subjects, private subjects, are also using the arbitration mechanisms under the arbitration treaties against the Russian Federation. We recognize the jurisdiction of the International Criminal Court, and the International Criminal Court now does conduct investigation of the situation in Ukraine. And moreover, recently, our National Parliament, Verkhovna Rada of Ukraine, has adopted several laws which amend the Criminal Procedural Code of Ukraine and makes the work of the Office of the Prosecutor of the International Criminal Court in Ukraine more effective. Now we do have a separate special chapter on cooperation with the ICC in Ukrainian Criminal Procedural Code. But since we are using all these mechanisms, instruments, and tools since 2014, we see that they are not enough. We see that we need to find some new answers to the questions and establish new tools in order to secure, how we call it, comprehensive accountability system for violations of international law committed in and against Ukraine. And as of now, our government sees two priorities, two new international possible tools, which needs to be established in order to secure this comprehensive accountability system. First tool is a compensation mechanism, which is about compensation of damages and losses which occurred due to the Russian aggression against Ukraine, with relevant compensation fund and international registry of damage. My dear colleagues from the Ministry of Justice of Ukraine are leading this track. And the second tool, which we consider important and necessary and indispensable actually, in order to satisfy the comprehensive accountability system, is the establishment of the Special Tribunal for the crime of aggression against Ukraine. We see that the Russian leadership has not been brought to responsibility for all its violations since 2014. And thus we deem it necessary that we need to find a way, we need to find an instrument which will bring in particular the representatives of the Russian leadership, political and military leadership, for waging the aggressive war against Ukraine. So in particular for committing crime of aggression against our country. We think that this element is really lacking in the contemporary architecture of international criminal justice, and thus we really think that the establishment of the Special Tribunal for the crime of aggression is necessary. Since we are widely using all the possible international legal tools, we do see that the International Criminal Court, since its active role and position, cannot investigate and prosecute for the crime of aggression due to the fact that it has jurisdictional restrictions set forth in the Rome Statute of the ICC. In particular, the Russian Federation has not ratified the Rome Statute and Kampala amendments on the crime of aggression, and it is obvious that it will not do this in the nearest future. And we also understand that the United Nations Security Council will not refer the situation to the ICC, stipulating that there was committed an act of aggression against Ukraine. Thus, the ICC cannot work with a crime of aggression against Ukraine.
I think Mr. Koronevich made his point, and now we are moving to the main part of our discussion, and I would like to invite Professor Milena Stato. She is a professor of law and at Cleveland State University's Cleveland Marshall College of Law, and managing director at the Public International Law and Policy Group. Please, Milena, the floor is yours.
Thank you so much, Anna. And as you mentioned, it is a shame that we were not able to hear the remainder of Mr. Koronevich's presentation, but I'm sure that we will actually get to all of his points through our discussion today. It is a real pleasure to moderate this conversation among these esteemed experts. My name is Milena Stato. I'm a professor, as you mentioned, at the Cleveland Marshall College of Law, and also managing director at the Public International Law and Policy Group. And I am really pleased to be here today. Thank you so much to the Global Accountability Network, the New York State Bar Association, and the Ukrainian Bar Association for putting this amazing event together. Our esteemed experts today include Ambassador Hans Corell, Professor David Crane, the former Chief Prosecutor at the Special Court for Sierra Leone, Professor Erwin Cutler, Ambassador David Sheffer, and also Alexandra Kachura, a member of Parliament in Ukraine, and then also my colleague, Professor Jennifer Trahan, who's actually here with me physically. Both of us are attending International Law Weekend in New York City, and both of us are actually coming straight from another aggression panel that Professor Trahan organized and moderated that Ambassador David Sheffer was also a participant at. So with that, let's begin our conversation. And my first question is actually for Professor Trahan, and it has to do with outlining the crime of aggression, the history of the crime of aggression, because as we will find out, the crime of aggression is not new, and we have had discussions around the crime of aggression for about a century. So with that in mind, let me turn it over to my colleague, Professor Jennifer Trahan.
Great. Thank you so much, Professor Stereo. It's a great pleasure to be here. So let me start with framing why we're talking the importance of the crime of aggression. It's, I guess, probably obvious to everyone who's in Ukraine and listening to us today. But without the aggression, we would have none of the war crimes. We would have none of the crimes against humanity. We would have none of the civilian killing, and we would have none of the military fatalities on either side. So this is, in the Nuremberg judgment, they framed it as the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole. And that is the thought. Without the aggression, we just wouldn't reach none of it. And therefore, the harm of the crime of aggression is so much greater than of all of the individual crimes, because it in effect encompasses all of them. But I want to frame today's discussion with a little historical precedent where this crime comes from. So I do commend Ona Hathaway and Scott Shapiro have written this book called The Internationalists, and they trace the discussions. In particular, in 1917, there were individuals in the US who were discussing how do we outlaw war, and then how do we have ramifications, enforcement of these provisions. And these discussions eventually led into the creation of the Kellogg-Briand Pact, an agreement to outlaw war. And of course, for anyone listening from The Hague, you will also know there's the Peace Palace in The Hague. And that was designed to house a permanent court of arbitration and later the permanent court of international justice, with the aspiration that states need to litigate and arbitrate and not use recourse to force. And of course, we have the seminal moment at the Nuremberg Tribunal that there must be individual criminal responsibility for the crime of aggression. And in popular imagination or thought, one thinks of the Nuremberg prosecutions as all about the Holocaust, and they actually weren't. The key focus at Nuremberg was on the crime of aggression. It was in counts 1 and 2 of the indictment. States then reinforced the prohibition against aggressive use of force in Article 2.4 of the UN Charter. You will know it has no automatic enforcement provision. So sometimes the Security Council is able to act under its Chapter 7 powers, but when you have a permanent member who is involved in the aggression, obviously the Security Council will be paralyzed, and that is because of the veto power. And under the UN Charter system, we also don't have individual criminal responsibility. Another important historic step is taken in 1974 when the UN General Assembly defines aggression in its resolution 3314. And a key additional step is taken already in 1998. The decision is made under the Rome Statute. There are 4 crimes, 4 core crimes, 4 atrocity crimes, with the crime of aggression already in the original statement of what the court would have jurisdiction over. They did not finalize that definition at that point, but it has to go into a separate negotiating process before the Special Working Group on the Crime of Aggression. So for a period of nearly 10 years, these negotiations continued. They came to a consensus definition of what is the crime of aggression. I attended the negotiations, and I can tell you the Russian Federation was present and part of these negotiations and in agreement with the definition. However, as you all will know, the International Criminal Court's jurisdictional regime on the crime is dramatically more limited. It has much more jurisdiction over genocide, war crimes, crimes against humanity. And unfortunately, the US played a key role in limiting the crime of aggression jurisdiction. This was in 2010 in Kampala, Uganda. It made the US and certain other states made the decision, which was then adopted, that non-state parties to the Rome Statute system are completely above the jurisdiction. And it is that decision that has now exempted Russian nationals from crime of aggression jurisdiction before the International Criminal Court. We also have the irony that the UK and France further narrowed jurisdiction in 2017. So we have the very ironic situation that 3 of the 4 Nuremberg allies have limited the jurisdiction. And when it comes time to try to use this crime against the successor entity, Russia, of what a large part of the Soviet Union, the ICC lacks jurisdiction. And in our definition, we see that the crime requires a manifest charter violation, a super clear charter violation. Well, there are sometimes gray areas in international law, but we are not dealing with a gray area in international law here. This has been a manifest charter violation. So it's been very clear. And if we've had a manifest charter violation under the definition of the crime in Article 8 bis of the Rome Statute, the certain military and political leaders who planned, prepared, initiated, or executed the crime have committed the crime of aggression. Our complicated question is, where do we prosecute this crime? And how do we get the tribunal started? So without taking more time, I'll turn it back over to Professor Stereo.
Thank you so much. Let me interrupt the flow of this discussion just for a second, because my understanding is that our Ukrainian colleague, Mr. Alexander Kachura, Ukrainian member of parliament, has limited time today, so unfortunately cannot stay with us until the end. So because of that, I'm going to turn to Mr. Kachura next and invite him to share his thoughts with us today.
Так, доброго здоров'я, мене добре чутно?
Так.
Так. Мене звуть Олександр Качура, народний депутат України. Я якраз є ініціатором постанови Верховної Ради про створення такого спеціального трибуналу, і ми цю постанову напрацювали спільно з Офісом Президента, з якраз Антоном Кореневичем, він як представник МЗС, з колегами від парламенту, і понад 30 народних депутатів підтримали цю постанову своїми підписами. Я хочу сказати, що на початок своєї промови, те, що це позиція всього українського парламенту. Не дивлячись на те, які у нас погляди є на ті або інші питання, весь український парламент, там понад 300 голосів, вони всі підтримали нашу постанову, і ми звернулися і до Парламентської асамблеї Ради Європи, і до всіх парламентських асамблей, які є, це і при Європейській Раді, і це також і відповідна асамблея при НАТО, з тим, щоб вони прийняли резолюції, це і парламенти наших країн, які ми називаємо вільного світу, тобто ті країни, які підтримують Україну. По-перше, хотів би сказати, що, тому що я вже так почав одразу вже говорити по темі, хотів би сказати, що для мене велика честь знаходитися на такому заході Асоціації правників України. Я сьогодні перевірив в своєму квитку, що я вже майже 10 років є членом цієї організації. І Асоціація правників України, вони залишаються, як і це було раніше, я б сказав би так, флагманом всієї юридичної спільноти і інноватором в усіх питаннях обговорення. І це дуже добре, що саме українські юристи, вони тут виступають лідерами в питанні обговорення, створення цього спеціального трибуналу, а також приймають активну участь в допомозі держави. Я знаю, що з перших місяців багато адвокатів, юристів, вони допомагали документувати ті злочини, які чинила Російська Федерація на території України. Тому що зрозуміло, що наша правоохоронна система, вона не була готова до цього в тій кількості тих злочинів, які є. У мене є цифри, я, на жаль, їх не можу публічно говорити в цьому форматі. Але це величезна кількість злочинів, які зараз розслідуються, і українськими правоохоронними органами, також і Міжнародний кримінальний суд буде ці питання розглядати. Як сказала попередня спікерка, вона дуже правильно підмітила, що Міжнародний кримінальний суд, він дає можливість тільки притягнути до відповідальності, це 3 виключних підстави: злочини проти людяності, злочини геноциду і воєнні злочини. Тобто сам акт агресії, який називають матір всіх злочинів, які потім відбувалися, він не є в юрисдикції, в компетенції цього суду. Тому і коли деякі колеги, парламентарі, вони кажуть, що ми створюємо конкуренцію своїм спеціальним судом, міжнародним спеціальним трибуналом, будемо так називати, щоб було більш зрозуміло, це точно не так. Ми не створюємо конкуренцію. Офіс Генерального прокурора і Генеральний прокурор Андрій Костін, вони співпрацюють з Міжнародним кримінальним судом. Тобто цей процес іде, але встановити взаємозв'язок тих жахів, які відбувалися в Бучі, в Ірпені, коли приходили солдати і знищували наших громадян, гвалтували наших жінок, і той людини, яка знаходиться в Кремлі, яка давала безпосередній наказ вчиняти акт агресії, тобто це дуже важко зробити. Натомість, якщо ми створимо міжнародний спеціальний трибунал, ми зможемо тут швидко розглянути це питання, ми зможемо і видати необхідні ордери на затримання вищого політичного керівництва, і ціллю міжнародного трибуналу є саме, спеціального трибуналу, є саме і вище політичне керівництво Російської Федерації. Тобто ті, хто безпосередньо планував з 2014 року і реалізовував акт агресії щодо України. На жаль, міжнародна спільнота у 2014 році, як це було на початку ще Другої світової війни, коли Гітлер розпочав свою агресію в Європі, так само і не оцінили всі Путіна плани. Тому що ми вже бачимо зараз по риториці вищого політичного керівництва Росії, що вони не зупинились би, якщо б хоробрий український народ і воїни українські не зупинили, вони далі планували рухатися в сторону Польщі, Литви, Латвії і так далі. Тобто це було озвучено представниками вищого політичного керівництва. Тобто зараз це питання не тільки справедливості в Україні і притягнення до відповідальності саме за агресію в Україні, а це питання взагалі існування безпеки в світі. Тут варто зазначити, що останні такі прецеденти, дійсно, тільки що казав про історичні моменти, це все було в 1940.
It appears that Mr. Kachura has temporarily frozen for us. Okay, with that, perhaps let's continue our discussion, and if he is able to rejoin us, we will certainly yield the floor back to him. So we heard from my colleague, Professor Jennifer Trahan, about the history of prosecuting the crime of aggression. And next, I wanted to turn to the different types of accountability mechanisms that exist that could theoretically prosecute the crime of aggression. So let me turn to Professor David Crane. He can start us off. Can you tell us a little bit about the different accountability mechanisms that we've seen over the past 20 to 30 years?
Well, thank you, Melina, and thank you to all my colleagues for taking your valuable time and being a part of this really important webinar. And to my good friends in Ukraine, my compliments to you and for your strength and your focus. That's an important question for our listeners: is what kind of justice mechanisms can we use? And really, there's quite a few actually methods of creating justice mechanisms. We've done this now for, dare I say it, almost 25 years. And we've established a panoply of experience, proper rules of procedure and evidence, and really some very, very key and important jurisprudence, which would assist both the International Criminal Court and also a future special tribunal for Ukraine on the crime of aggression. But the types of justice mechanisms that are theoretically available are, for example, the ad hoc concept of a tribunal established generally by the United Nations under their Chapter 7 authorities. And we've seen that done in the various international criminal tribunals for Yugoslavia and Rwanda. Also during this time frame, a new idea came about, which I was very much involved with as my colleagues Erwin Kotler, David Scheffer, and Hans Corell, and that is an international hybrid tribunal made up of both international jurists as well as local jurists, and one of which was the first one was the Special Tribunal or the Special Court for Sierra Leone, excuse me. And that is potentially a model, and the model that I have kind of advocated in a recent July white paper related to setting up a special tribunal for Ukraine on the crime of aggression. So we have both an ad hoc tribunal, an international hybrid tribunal, but we also have various other regional and local domestic kind of justice mechanisms, like extraordinary chambers that we had in Cambodia. Those are also very important, but we also turn to regional actors, such as the African Union, dealing with various actors that have committed atrocity crimes throughout that region as well. Now, the approach to dealing with the aggression issue in Ukraine, in reality, can be done both regionally and internationally. You could establish a type of court for aggression that would be European-centric, through the European Union and various other entities. And then, of course, you have the United Nations, and the reality is that it would have to be the General Assembly that would act and recommend to the Secretary General to enter into a bilateral arrangement with Ukraine. So those are in general, those are the justice mechanisms that have been used in the past successfully, and also the potential for dealing with the crime of aggression. Of course, excuse me, we've also had the permanent criminal tribunal, and that is, of course, the International Criminal Court. And I apologize for that. I can't believe I forgot about that. But so in sum, we have an ad hoc tribunal, we have hybrid tribunals, we have various regional actors that could be mechanisms. Then we also have, very importantly, our permanent international criminal court in the ICC in The Hague.
Thank you so much, David. Now, pardon the interruption of our flow again, but I see that Mr. Kachura was able to rejoin us. I would like to invite you, if you will, to continue your presentation. I understand that there was a temporary power outage, so I'm glad you were able to rejoin us. Please.
Хотів би тут до наших міжнародних партнерів, колег звернутися, тому що ви нам дуже допомагаєте, без вас би ми не змогли чинити такі опіри російській агресії. Але я зараз, я парламентар український, я знаходжуся в центрі Києва, в Печерському районі міста Києва, багатоквартирному будинку. І завдяки тому, що акт агресії, який відбувається щодо України, вчиняється щодо цивільної інфраструктури, це є воєнним злочином 100%, але це робиться за вказівкою вищого політичного керівництва. У нас зараз масово відключається, енергосистема не витримує, і ці атаки продовжуються. Це може бути завтра, післязавтра. І ви бачите, що навіть ми, члени парламенту, ми теж, як всі українські громадяни, розділяємо те, що відбувається. І це те, з чим тільки нам доведеться потім зіштовхнутися в цю зиму. Ця зима буде дуже надзвичайно важкою. Тому ми все-таки розраховуємо на величезну підтримку від наших партнерів і далі. Так от я продовжу свою думку, що дійсно в історичному контексті в нас була остання, це Нюрнберзький та Київський трибунал. Можете мене поправити. Це буде схожий трибунал по вищому політичному керівництву Російської Федерації, який повинен невідкладно буде розглянути це все швидко, видати ордери необхідні для затримання. І тут я вже буду говорити про те, як це буде відбуватися. Ми бачимо декілька шляхів. Це може бути, наприклад, або підписаний договір між країнами, це може бути підписаний угода, наприклад, з ООН, це може бути підписана угода з ЄС або Радою Європи. Найбільш я особисто, це не є всієї влади позиція, моя особиста позиція, що це повинна бути угода між державами. І як тільки представники вищого політичного керівництва наше вище політичне керівництво, хто вчиняє щодо нас агресію Російської Федерації, вони потраплять на територію цих країн, вони повинні будуть невідкладно затримані, доставлені до того трибуналу, який буде створений. Я б ще раз хотів би акцентувати увагу, що ми не є конкурентами, наша ідея не є конкурентною Міжнародного кримінального суду. І дійсно в деяких випадках Міжнародний кримінальний суд може розглядати таку категорію справ щодо агресії, але для цього необхідно, щоб і Україна, і Росія ратифікували Кримський статут Міжнародного кримінального суду, так і Кампальські поправки про злочин до агресії. На сьогоднішній день, оскільки в Росії не працюють жодним чином норми міжнародного права, це абсолютно є неможливим. Тобто ми це розуміємо. Тому єдиний вихід – це створення. З цією ідеєю виступив Володимир Зеленський, президент України. Ми бачимо зараз підтримку серед колег. Ми спілкуємося з багатьма парламентарями інших країн. Ми бачимо, що європейське суспільство – це в першу чергу цінності, і це ж не якісь економічні, тому що, на жаль, у 2014 році багато хто з політиків західних, вони казали про те, що необхідно домовлятися з Путіним, і створення такого трибуналу, воно призведе до того, що ми не зможемо домовлятися, торгувати, наша економіка постраждає. Зараз всі європейці, вони розуміють, що вже все, вже пройдено точку неповернення, і треба підтримувати цю ініціативу, створювати міжнародний трибунал щодо вищого політичного керівництва Росії і дійсно говорити вже про колективну безпеку Європи. Тому що ті стандарти, і про це теж казав президент неодноразово, ті стандарти, які були раніше, вони вже не діють. Тобто світ уже ніколи не буде таким, як він на початку 2022 року, бо він вже ніколи таким не буде. І тому питання того, наскільки зараз буде залучена вся міжнародна спільнота, всі юристи, це тут дуже поважний склад цієї конференції. Наскільки ми докладемо до цього зусиль, буде питання стояти, чи повториться це знову. І я б хотів би, ви знаєте, тут сказати, вже завершити свій виступ. Я надіюся, що в мене вистачить необхідної кількості електроенергії для того, щоб я завершити. І ми тут, до речі, вибух, що був декілька днів назад поряд. Так от, я б хотів би його завершити не як політик, не як член парламенту і навіть не як юрист. Я б хотів би просто завершити як людина. Питання створення міжнародного трибуналу щодо акту агресії, який вчиняється в Україні, це питання існування взагалі подальшого людства. Тому що цей ось, я б сказав би так, Путіна вчинок, він може бути неоднократно повторений в інших країнах світу. І будь-де, якщо зараз міжнародна спільнота не дасть відсіч тому, що відбулося, якщо ми не покараємо це зло, яке відбувається, це буде повторюватися знову і знову. Політики завжди казали європейські ніколи знову. І це ніколи відбулось знову в 2014 році і продовжилось в 2022 році. Тому я надіюся на підтримку, я завжди відкритий, я залишу свої контакти організаторам цієї конференції. І український парламент, і ми створили міжфракційне депутатське об'єднання, яке вже війшло понад 50 народних депутатів від різних фракцій. Тобто це об'єднання з різних політичних фракцій. І у нас є така форма в українському парламенті законодавством передбачена, яка називається «Трибунал для російських агресорів». Ми готові, відкриті до співпраці. Ми будемо теж робити конференцію велику в найближчий час, можу вам такі сказати інсайди, будуть залучені міжнародні експерти, тому будемо бачити раді вас на цьому заході, представників асоціацій, представників різних інших організацій спільноти української та міжнародної юридичної. І я надіюся, що за моїми прогнозами, вже в наступному році такий трибунал може бути створений. Це мої особисті відчуття. Я спілкуюся з багатьма і парламентарями, і юристами в світі. Я надіюся, що ми пройдемо цей шлях, і це зло буде покаране, агресія буде покарана. Дякую вам за можливість виступити. Дякую.
Thank you so much for joining us, especially under such difficult circumstances. I really appreciate you being with us today. With that, I would like to continue our discussion of the different accountability models. And David Crane has outlined for us the existing accountability models, including prosecutions in national courts, ad hoc tribunals, the ICC. But as we all know it, several of those cannot prosecute the crime of aggression. So with that, I would like to invite first Ambassador David Scheffer, if you can tell us a little bit more about why is it that national courts and the ICC cannot prosecute the crime of aggression? You know, why is it that we need a special tribunal for aggression?
Well, thank you so much, and I appreciate it, and to be with all of my colleagues on this this conference. I think let's start with the ICC. The International Criminal Court has now a long history of addressing the crime of aggression, including in its original statute in 1998 as a core crime of the court. It took more than a decade to bring that to life as an operational crime, and then another 7 years to achieve sufficient ratification so that it, in fact, really is activated at the International Criminal Court. The problem with applying that with Ukraine is, first, Ukraine is not a state party of the court, even though it has filed the 12.3, the application, which would normally trigger the jurisdiction of the court for the crime of aggression if Ukraine had been a state party and accepted the crime of aggression amendment. But that is not the case. Secondly, there is a provision in the Kampala amendments that brought about the crime of aggression as an operational crime that excludes from liability under the Rome Statute the nationals of non-party states. This was essentially a big power move at Kampala that was joined by the United States, by Russia and others who were all non-parties pressing this forward. But then some other state parties joined with them to actually bring this to the fore. And it was, I think, seen very much as a lubricant for actually getting the crime of aggression through the Kampala Conference and off towards ratification as an amendment, as a politically palatable amendment to the Rome Statute, with all of its flaws, the amendment itself, with that exclusion in it. So that takes the ICC off deck, a very ironic and almost paradoxical dilemma that we face with the International Criminal Court, but that is the reality. National courts could, of course, take this up, whether it be in Ukraine or elsewhere in Europe, exercising perhaps universal jurisdiction with respect to the crime of aggression. I would consider that to be a highly unlikely prospect because it's politically toxic for any European government to actually take that up in its national courts. I mean, theoretically, you could do it in certain countries that would have jurisdiction over the crime of aggression, such as Germany has, within its own domestic criminal law. But it would still be a very politically toxic thing, very, very difficult for a government to be supportive of its courts actually doing that at the national level. Not to discourage it, but frankly, I think that would be the reality. So that brings us to the kind of special tribunal that many of us in academia have been putting forward, and that our three distinguished presenters, David Crane and Erwin Kotler and Hans Karel, have put so much work behind in trying to figure out how to do this in a way that would work. And it could work with a special tribunal. There are many details that have to be worked out, of course. There has to be a good relationship between the special tribunal and the International Criminal Court, because both courts would be looking at probably almost the same set of suspects, whether it be in the planning and execution of war crimes, crimes against humanity, or even genocide at the leadership level. And that's where the ICC focuses its attention. or for the Special Tribunal at the leadership level for the crime of aggression, which itself by definition is a leadership crime. So I think it's extremely important that we focus on what that relationship would be between the ICC and the Special Tribunal. And I believe that it could be worked out. There are many factors that come into play there, but we already have a relationship agreement between the United Nations and the International Criminal Court. The Special Tribunal would be a UN-created tribunal through a treaty between the UN and the government of Ukraine. And I would argue one might interpret the relationship agreement as frankly applying, if so chosen by the parties, to the Special Tribunal. In other words, they could agree in their treaty that the relationship agreement between the UN and the ICC would have some governing authority with respect to the conduct of the Special Tribunal in terms of sharing evidence, cooperating with the ICC on cases. And frankly, it would almost be to the benefit of the ICC because the relationship agreement would give the ICC, shall we say, primacy in how cases would go forward, who might be prosecuted first, who would stand trial first. The ICC would have sort of a governing hand in how that's decided between the two institutions. And in my view, that's fine, that's okay. International criminal justice is the long arc. It will take many, many, many years for this to play out. And if that means that custody is achieved over any of the indicted fugitives, then I don't see a great complication in that individual standing trial first before the ICC for the 3 atrocity crimes of crimes against humanity, war crimes, or genocide. And then when that is concluded, whether it's a conviction or a critical acquittal, you cross the street to the Special Tribunal in The Hague, and the trial commences on the crime of aggression. The point is to nail the person to the wall for the rest of his life, and that would do it.
Thank you. Now, before we move on to more specific questions regarding the possibility of establishing the Special Tribunal for Aggression, I wanted to invite Ambassador Hans Korel and Erwin Cutler to also weigh in on the general issue of the need and the desirability of establishing a Special Tribunal for Aggression. Ambassador Korel?
Thank you very much, and thank you for inviting me to participate in this conference with colleagues and friends. I would just like to make 5 very brief points to sort of try to describe in a nutshell how I see the situation. My first point is that it is crystal clear that Russia has committed a crime of aggression against Ukraine, a clear violation of one of the most fundamental provisions in the UN Charter, namely Article 2, Paragraph 4. Second, because of this, the world community simply must react. It is not possible to allow this just to pass by. Russia's aggression reminds us of what happened in the 1930s and the following disastrous development. Third, since the International Criminal Court does not have jurisdiction over the crime of aggression, it is necessary to establish a special tribunal for the purpose of bringing the perpetrators of the crime of aggression to justice. Fourth, the question is then how to proceed. It is necessary to act swiftly. Therefore, solutions that require negotiations of an agreement between several states and may be requiring ratification by national parliaments is simply not possible. The tribunal should be established under the auspices of the United Nations. And here we have a model that is functioned perfectly in the past, as David Crane mentioned, namely the Special Court for Sierra Leone. This model means that Ukraine would request the General Assembly to ask the UN Secretary General to negotiate an agreement with Ukraine establishing such a tribunal. At Kofi Annan's request, I negotiated the agreement between the United Nations and Sierra Leone, which I signed with their Minister of Justice, Solomon Bareva, on the 16th of January, 2002. From this experience, I know that this method is extremely effective. As a matter of fact, an agreement between the UN and Ukraine might be finalized after some 4 or 5 weeks. And lastly, a fifth point. The tribunal should be based in The Hague for the simple reason that it will be complementary to the International Criminal Court. And as David Scheffer developed here, I don't think there is any problems with this relationship. On the contrary. And then the Special Tribunal will be able to rely on almost all the evidence that the International Criminal Court is gathering. That evidence will prove the effects of the aggression crime. The evidence that proves the crime of aggression lies in the statements and actions of the Russian state leadership. So this would be in 5 points, in a nutshell, how I see the situation. And I think it's very important to use the evidence, the experience we have with the Sierra Leone Tribunal here. And before that tribunal, as you may know, Charles Taylor, head of state, was brought to justice, and he's now serving a long sentence, prison sentence, because of the crimes that the court found him guilty of. So this would be my scene here. Thank you.
Thank you so much. And we will definitely have the opportunity to return to some of these themes and some of the points you just raised. Erwin Cutler, what are your thoughts about the establishment of a special tribunal for aggression? You are on mute still, if you can press the unmute.
Thank you. Thank you. May I begin by saying how pleased I am to participate with my colleagues and join with them on the theme that you just expressed about the need, I would say, urgency for the establishment of this tribunal. Earlier today, I participated virtually in an international conference in Berlin on Russia's criminal aggression and accompanying mass atrocity crimes in Ukraine. In particular, I was asked to focus on Russia's breaches of the Genocide Convention set forth in a report that the Raoul Wallenberg Center for Human Rights, which I chair, published in late May and endorsed by leading genocide scholars, those that are on this panel. The report had 3 main findings, but the reference that I make to them now is because each and all of them themselves underpin the importance, the imperative, the urgency of establishing such a tribunal. The first finding is that Russia is in standing breach of the Genocide Convention's prohibition on the direct and public incitement to genocide. It is sometimes forgotten that this is a stand-alone crime under the Genocide Convention, as the Supreme Court of Canada put it in its own series of cases and findings, that the very incitement to genocide constitutes the crime, whether or not acts of genocide follow. And we have seen with regard to the Russia's criminal aggression in Ukraine that it has sought to justify that criminal aggression through the very lens of incitement using the denazification theme, and therefore has sought to justify the crime of aggression through this false accusation in the mirror, as it has been called. In other words, this ongoing dehumanization and demonization by senior Russian officials, the utilization of the denazification theme, and the false accusation in the mirror, which is a powerful, I would say, historically recurring form of incitement that we have seen in other genocidal killing fields, and where the perpetrator, Russia, accuses the protected, targeted group, the Ukrainians, of being themselves the perpetrators of the very mass atrocity crimes and genocide that they themselves are engaged in. The second finding is that genocidal intent can be inferred from the crime of aggression itself and the accompanying mass atrocity crimes. And there is evidence of this in our report on Russia's state plans to document statements, policies, etc., which form a systematic pattern of mass atrocity crimes targeting the Ukrainians as a protected group. It includes all the things that references have been made to, and that we know: mass killings, deliberate attacks on civilians, indiscriminate bombing, deportations. I can go through, but you know all these things. But this leads to the third and final finding, which underpins the need for such a tribunal. And that is, along with the crime of aggression and the direct and public incitement to genocide and the mass atrocity crimes, war crimes and crimes against you, all of this have created a serious risk of genocide, and thereby mandate the duty of state parties to the Genocide Convention to prevent and protect against genocide when this threshold of a risk of genocide has been reached, as it has been reached here. And when that threshold has been reached, then this creates an obligation on the state parties to prevent the genocide and mass atrocity crimes, not to await until such a genocide actually occurs. That's the whole point of the Genocide Convention, on the prevention of such crimes. And therefore, in that context, and with that imperative, we should see the establishment of this independent tribunal on the crime of aggression as an urgent framework. To borrow David Sheffer's comment, the long arc of criminal justice can be secured through this international tribunal, which, while addressing the crime of aggression, will also be underpinned by the incitement to genocide, et cetera, that I've discussed. Thank you.
Thank you so much. Now, we have received an excellent question from Alexandra Yanovska, who is a Supreme Court judge in Ukraine specializing in criminal law. And her question is really twofold. Part of the question has to do with the collection of evidence. So if there's a special tribunal for aggression established, and if that tribunal collects evidence, could that same evidence also be used by the national courts of Ukraine, which also under Ukrainian national law can prosecute the crime of aggression? Because can the same evidence be used by essentially two different accountability mechanisms? And then her second question has to do about actually the possibility of bringing Putin to justice, arresting Putin, physically transferring him to the custody of the court. And as she very aptly notes, as of today, more than 12 arrest warrants issued by the ICC have not been executed. So let me turn to my colleague, Jennifer Trahan, first, and then I will open the floor to the other panelists as well.
Thank you. And thanks for that question. It's wonderful to have a judge listening to the panel and giving us her wisdom. In terms of evidence sharing, these kinds of arrangements can be made. They would need to be made. And I think it would be, imperative. We are talking different institutions, and cooperation and not duplication always has to be ensured. The judge mentioned that Ukraine has a crime of aggression on its books. And I think the one thing we haven't discussed yet today is immunities. So we have this unfortunate language in paragraph 44 of the Erodia arrest warrant case from the International Court of Justice. And it basically ruled that there is no immunity for heads of state, heads of government, foreign ministers before an international tribunal. And that was a case coming out of Belgium, and the minister had immunity there. So when we look at crime of aggression, which we say it's a leadership crime, so that means at least in the 8 bis definition of the Rome Statute, it only covers a person in a position effectively to exercise control over or to direct the political or military action of a state. So it's not as narrow as Putin. It is broader than that. It's political and military leaders, but it is these leaders. And then if we have immunities, then the leaders cannot be prosecuted in national jurisdictions. And I think this is unfortunately true of Ukraine. It would be true of third-party countries. So if Germany started a prosecution, they're going to hit immunities issues as well. And we actually don't know what the answer would be for a regional or pooled jurisdiction tribunal. So the Eurodia decision said there's no immunities before international tribunals. And interestingly, they named the Sierra Leone Special Court, which did, of course, have some degree of hybridization. But then they said the International Criminal Court and like the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, which is why many of us go back to really the best way, if you want to go against the leaders, is it has to be an international tribunal. And that is where we're talking, you know, the best way to do it is through the United Nations. And also because this isn't just a crime that impacts European countries. This is actually about the global order. Every country has an interest in ensuring the sanctity of its borders. This is a question for the world to grapple with. And I saw the judge's question at the end asked, well, how do you get the accused before the court? How do you get Putin? Well, it's not only as narrow as Putin, it's a broader number that would be picked up in the definition. And the judge noted the outstanding arrest warrants before the ICC, which is indeed problematic. Some have gradually been surrendered and turned over, but as David Crane can well tell us, you know, there probably were days when they wondered how would they ever get Charles Taylor before the Sierra Leone Special Court. And we do also have the important ruling. He was indicted while an acting head of state, and a motion was made that he had immunity, and the Sierra Leone Special Court ruled he does not have immunity. And we have the same result on the ICC ruling on Jordan's non-cooperation in the arrest of President Bashir. At that point, still the president of Sudan, and it held he did not have immunities, and Jordan should have undertaken the arrest. So we have important precedent that the immunities don't attach at the international level. We need to utilize this. But I think just as the Special Court probably, you know, had sleepless nights. How do you get Charles Taylor to the court? And he emerged there. Many, many years ago, I was at Human Rights Watch where we started Arrest Karadzic and Mladic campaigns. And at that point, you know, it seemed inconceivable how you would get Karadzic and Mladic to The Hague. And similarly on Milosevic. So, you know, we were just, well, we campaign and you do the press releases and you try and you put pressure until, and it did come to pass. So I guess I have that optimism. Even an indictment, however, is a very powerful statement. I'll leave it there.
Thank you. I see that David Crane has his hand up. I suspect you're going to agree with Jennifer, but please go ahead. You're also on mute still, David. Go ahead.
Of course, I agree with Jennifer, my good friend of 20 years, and she makes some excellent points. You know, I'm not trying to toot my own horn, but I'm the guy that took down President Charles Taylor. I'm the one who investigated him, indicted him, and then politically set up a scenario in Ghana where he was went up the steps during a treaty negotiation. And 5 minutes later, he came down as an indicted war criminal. I did that intentionally. And of course, I don't want to go too much into detail with that. But just as an aside, you know, President Charles Taylor, the sitting head of state of Liberia, made a tactical blunder when I indicted him and sealed that indictment initially. We waited for a political moment to take him down in front of the world, which we did on the 3rd of June of 2003. Now, he immediately questioned the indictment, went after the indictment, had done so earlier on through his attorney before our appellate chamber on a jurisdictional issue saying, if I'm indicted, because he didn't know I actually indicted him, if I'm indicted, I can't be, you can't get me because citing the Erodi decision and head of state immunity. He made a very tactical blunder there because he wasn't, he went before the court questioning the authority of the Special Court for Sierra Leone to potentially indict a sitting head of state, knowing that, that guy over there in Sierra Leone may just do that. So he went actually before our appellate chamber. I questioned his standing to come before the appellate chamber because I hadn't indicted him, but interestingly enough, they allowed him to argue that if by chance someday he's ever indicted, that they can't do it, or I can't do it because of head of state immunity. He lost on the issue. And so I was saying, well, here we go. So there was the legal floor by which then as I began to, and I eventually did indict him and then sealed that indictment, waiting for that political moment. And truly, this is important. Indicting a sitting head of state is a political issue. We have the jurisprudence, as Jennifer has importantly pointed out. We have that. It's really, you can't very much argue that a special tribunal for Ukraine on the crime of aggression wouldn't have jurisdiction. One is we put it in the statute, but also there's jurisprudence that back this up. So again, it's just one of these things where we could do this. And so Charles Taylor, I unsealed the indictment intentionally, a political decision on my part, to humble him before the world and to let the world know that Charles Taylor had committed these crimes, of which he was subsequently found guilty of. So the importance of the points that I'm making here is that, well, what if we never get the guy? Well, it took me personally 2 years of my life to get him handed over to the Special Court for Sierra Leone for a fair and open trial. 2/3 of my time as chief prosecutor was traveling the world, talking to heads of state, parliaments, Congress, senators, foreign ministers, ministers of justice, talking about how we actually hand him over. Because when I did unseal the indictment, he was stripped of his power and put into some kind of house arrest in Nigeria. So it was a political, most of my work at that time now was political, just trying to build a consensus that this must be done. And the world did decide to do this, and politically they handed him over to us. And then legally we found him guilty of aiding and abetting, and he was found guilty largely on my indictment of all counts. And now he's serving 50 years in a prison in the United Kingdom. But the point is here is that, all right, so what if by chance we don't get Putin personally at this point? Someday there may be a political circumstance by which the people of Russia will hand him and others over. And this is also an important footnote to highlight, is, we're not just going after Putin, on the crime of aggression. We're also going after his foreign ministries. We're going after his Minister of Defense, the National Security Council, all his senior commanders that affected that, to include potentially aiding and abetting the crime of aggression. So the fact that we don't physically get Vladimir Putin now or 3 years from now or forever, the key is, and Jennifer makes this point, is that we have to do it. We have to indict him and his henchmen for this. We may prosecute his henchmen. We may actually get jurisdiction, physically have these individuals, but we have to indict Vladimir Putin as a sitting head of state on the crime of aggression, because there are other strongmen around the world sitting, watching like crocodiles as to how the United Nations takes action against a sitting head of state for the crime of aggression. If we do nothing, then it's going to be a very dark world indeed. China, North Korea, Iran, et cetera, will feel free to do whatever they want to do. And, really at the end of the day, if the United Nations does nothing about this crime of aggression, I'll just pose this rhetorically. Why do we have a United Nations? This is what it was set up for in 1945, based on the horrors of 1930s in the aggression of Nazi Germany.
Thank you, David. And that was actually a perfect segue. I was going to go to Ambassador Hans Karel next, who has his hand up. You mentioned the United Nations. Well, we have a UN expert here with us. So Ambassador Karel, the floor is yours.
Yes, thank you. Well, first of all, I would say that I agree entirely with Jennifer Trahan and David Crane here. This is so important. We simply must do something here. And it is important that we have this tribunal established, that there is a prosecutor appointed, and that the prosecutor starts an investigation. And then there should be an indictment. And this indictment should not be secret, because I think everybody knows who may be the suspects. It's better than to publish the indictment so that the whole world sees what these people are suspected of. This is absolutely necessary. And I mean, if I look at the United Nations, we should respect the heritage that we received from a generation that had experienced 2 world wars, the United Nations. And then we have the General Eleanor Roosevelt's work on the Universal Declaration of Human Rights, and then all the work that we've done here to establish justice, criminal justice at the international level. And since I was involved in the work of establishing all these tribunals that we talked about, the Yugoslav Tribunal, the Rwanda Tribunal, the Sierra Leone, and the Cambodia, etc., we should perform here. And I would say that we cannot go here like Sierra Leone to the Security Council because there is a veto there. But I also negotiated the agreement with Cambodia, and Cambodia did not go to the Security Council. They turned to the General Assembly, and the General Assembly asked Kofi Annan for an agreement. So this is the technique we should use, but the model should be the Sierra Leone, Special Court for Sierra Leone. Thank you.
We have Erwin Cutler next, and I know that Jennifer also wants to add a thought. So Erwin, go ahead.
Yeah, I just want to link up with what Hans said earlier and what David and Jennifer have been saying, the two Davids. The first thing, when Hans spoke about it clear that Russia has committed the crime of aggression, then he said that the world must react, reminding him of the 30s. And next month, as it happens, we'll be commemorating the anniversary of Kristallnacht, of November 9th and 10th, where thousands were deported to concentration camps, etc. I won't go into the whole thing, Kristallnacht, but it's often spoken of as the forerunner of the Holocaust. But I think what's important, what's relevant for us here is that Kristallnacht did not happen by accident. In other words, Dachau, the concentration camp, was established in 1933. The Nuremberg race laws were adopted in 1935. State-sanctioned incitement to genocide was proceeding from 33 to 38. In other words, the indifference and inaction led us down the road to Kristallnacht, which then led us down to the Holocaust. And I think the same thing here. Therefore, the sense of urgency that all have been talking about, and as Jennifer said, that indictment itself is a powerful statement. And David Crane showed how it not only can be a powerful statement, but it can work. And I would just like to close and say that when we look at the pattern of Putin's aggression, what happened here was an international indifference and inaction to Putin's and Russia's culture of corruption and criminality, which incentivized a culture of impunity. So when Putin went into assaulted Chechnya, we did nothing. When Georgia was invaded, we were indifferent. When the Crimea, etc., was annexed, the bombarding of Syria, and along with this, massive domestic repression was taking place. And so such a tribunal is necessary to combat the culture of impunity, which has been incentivized by indifference and inaction. And it's not only found expression in international crime of aggression, but in massive domestic repression. And where, at this point, a hero of the democracy movement in Russia, Vladimir Kara-Murza, has not only been charged with a law consequent upon the crime of aggression of not even being allowed to speak about the war, but now that has been turned into a crime of high treason. So I think establishing this tribunal will not only combat cultures of criminality and corruption and impunity, but also send a signal to people, the Vladimir Kara-Murzas in Russia, that we are standing in solidarity with them, that there is a nexus between domestic aggression, externalized aggression, and indifference and inaction, and therefore the urgency to act.
Thank you. And I know that Jennifer has a thought to add to this question, this issue.
It is difficult to speak after the powerful words of Erwin Cutler, but his words on inaction bring us back to David Sheffer and I were just on an earlier panel on this very same topic, and there was a young student from Taiwan in the audience. And I think it resonated very much when we made the point that, you know, if we had had a stronger reaction to the invasion of Crimea, maybe we wouldn't be in this place today. And none of us want to be in a situation where Taiwan is invaded and we're saying, oh, if only, you know, we'd had an international response and criminal prosecutions because of following the invasion of Ukraine. So inaction is really dangerous in this situation, and it's dangerous for the entire world order. Just one mini point, I know Sierra Leone Special Court has been suggested as a model, and in some ways I think it is a terrific model, in particular because it was more of a lean and mean focused court on only a certain number of indictments. And I think that's what we're talking about for the crime of aggression. The decision to invade is made by this leadership group, and that's who needs to be prosecuted. I mean, one of the features of the Sierra Leone court, it was a hybrid tribunal. So the judges were from Sierra Leone and the international community. And I make this comment somewhat, it was some concern because I know I'm speaking to a Ukrainian audience and potentially Ukrainian judges. I do think there's a concern in the situation whether, as talented as they undoubtedly are, and they could be of the utmost caliber and quality, will Ukrainian judges be seen to be impartial in the eyes of the international community on this kind of crime? I do think when you go after someone of the level of Putin, you actually want to, you know, have all of the fair trial protections, and, you know, ironically, he gets procedurally a perfect trial and all the fair trial protections if you're really going to make strong precedent. So here I raise the issue of the appearance of impartiality. And it is, I've had the privilege of working with David Sheffer, Ona Hathaway, Astrid Reisinger-Corrasini, and Klaus Kress. It's for this reason that we suggested it would be better to have the judges all internationally appointed. Of course, these are just models we're suggesting, you know, and with great deference to David Crane and Hans Karel and Erwin Cutler have suggested a model. We have just slight differences. And ultimately, these decisions are for the UN and Ukraine. But I do raise this just in terms of the appearance of impartiality. It could be a concern.
I see that there are reactions to Jennifer's remarks. So let me go to David Crane, and then Ambassador Hans Karel is next.
Well, thank you. You know, we have to step back here, and that is, why do we have justice mechanisms in the past and now in the present and in the future? It's for and about the victims. And if we lose sight of that, then we really have a real problem as to why we're even doing this. So I want to make that point. One of the reasons why the Special Court for Sierra Leone was so successful is that we did bring in jurists, investigators, prosecutors that assisted us in Freetown, Sierra Leone, in our town hall programs where we walked the countryside. The people, the victims, remember, can't forget the victims, felt that this was their court, that this was helping them. We have to be very honest here. You know, international tribunals are seen skeptically in various parts of the world. In some ways, it's European justice. And frankly, I even called it white man's justice because it was something that was brought in and kind of laid over the victims. Whereas in the Special Court for Sierra Leone, it was their court. They saw their judges, their investigators, their prosecutors and barristers going into court representing them to do this. So even though it's an option that Jennifer is projecting, we have to remember Ukrainians have to see this special tribunal as their court. And the best way to manifest that is through visible participation by jurists, barristers, investigators, also assisting the tribunal in their work. So there's my point.
Thank you. Ambassador Carell.
Well, I agree with David Crane here, but it is a sensitive question. And the situation in Sierra Leone is different, was different than the situation in Ukraine. And in our proposal, the proposal that Erwin Kotler and David Crane and I have brought forward, we have followed the model in the Sierra Leone, but we also indicated in the proposal that an alternative is that all the judges should be foreign judges on the court. And this is an element that I think should be carefully discussed between Ukraine and the United Nations when they negotiate an agreement. Thank you.
Thank you. And actually, that is one of the questions that we received through the Q&A, which is to say who should become a judge and a prosecutor. Perhaps you know their names and their nationality. I don't think that any of the proposals that I have seen thus far are as detailed as to actually suggest names for these positions, but the one point that we just discussed that is perhaps a little bit more difficult is whether to have all international judges or whether to include some national judges for all the reasons that we just mentioned. Now, I do have to ask the one, difficult question. I think we are all in at least theoretical agreement that there ought to be a special tribunal for aggression created. But here's my question. In light of US opposition, in light of French opposition, in light of, seemingly ICC prosecutors' opposition, how do we actually get this done? So let me go first to Ambassador David Scheffer. Perhaps, you worked in the US government, how do you get around, and, you're working now on this proposal with Professor Trahan and others. So how do you get around US opposition? How do you actually get this done?
Well, I have yet to see really firm evidence of US opposition. There's a tremendous rumor mill about, but frankly, at the end of the day, it might be a situation where the United States, for any number of reasons, I guess I could concoct at this point, would simply acquiesce or stay silent on this. You don't have to have the United States out there beating the drums to create this special tribunal. What you really need is for the United States to simply stand aside, acquiesce in it, not oppose it. And I think that's probably the strategy that is at least a very viable option on the sit room table in the White House with respect to this concept. We don't always have to be at the forefront of everything. And in fact, I've been arguing, the United States needs to take a posture now of collaborative leadership in the world, not leadership per se, but collaborative leadership in the world. It's also the case that we saw, and Hans will I know agree with this in 100%, that when you start down the road of building these hybrid tribunals, it often is a multi-year process of political building. Now, I think in the case of Ukraine, in other words, building the political support for it, I think in the Ukraine, we don't have to wait that long because Ukraine is in our face every single day. Cambodia, Sierra Leone, Lebanon, they were not in our face every day, but Ukraine is. And I perfectly agree with Hans. If enough political will were put to the task, two things could be done. What Hans said was 5 weeks of negotiation. Yes, you could plot a 5-week intensive negotiation between UN lawyers and the government of Ukraine, and it could get done in 5 weeks. I firmly believe that. But secondly, Ambassador Venevesar of Liechtenstein is at the forefront of trying to build a coalition at the United Nations for a tribunal of this character. And I would like to see some of our major parties, including behind the scenes, very discreetly, the United States government, pushing that issue forward within the General Assembly, among Latin American countries, among Asian governments, among African governments, to build the kind of political coalition that you need to get that resolution moving in the General Assembly. That's very hard, intensive diplomacy. And with Christian Van Weesar sort of at the head of it, I think it's entirely plausible to initiate that. But at some point, it is behind the scenes where this diplomacy has to take place, having had a big push by the Ukrainian government of its support for it. And then you've got to let the process germinate within the General Assembly body of countries.
Thank you. Would any of our other panelists like to weigh in on this issue of sort of how do we get this done? And you know, Ambassador Scheffer, I absolutely agree with you that you make a very good point that, you know, the United States doesn't necessarily have to take the leadership on this. It simply has to stay silent. I think that's a very important point. Erwin Cutler? Mute. You have to unmute. Thank you.
Addressing the question of how do one get around opposition, I agree with David Scheffer. I'm not seeing that the U.S., you know, expressing any opposition to it. And I just want to mention the expressions of support that I have seen on an international level. At a side event at the UN General Assembly, when it began in September, you had one foreign minister after another getting up and supporting the idea of a permanent, of an independent tribunal. Canada has now assumed the chair of the Executive Council of the Community of Democracies. I met just past week with our Foreign Minister, Melanie Joly, and I said, you know, this is an occasion for Canada to exercise its leadership as chair to advance the proposal for the establishment of an independent tribunal. And I'm hopeful that, in fact, Canada will do that. And as it happens, U.S. Secretary of State Tony Blinken is coming to Montreal in a week's time, meeting with Minister Joly. And I've asked that that be a subject matter of discussion, in that the U.S. may not publicly support it, but it will, as David Scheffer said, you know, acquiesce in it. And I think the meeting that I participated in virtually in Berlin today, I have to say that every senior person who spoke in this conference in Berlin this morning supported the idea of a permanent independent tribunal, and that brought together foreign ministers, high-level civil servants, and the like. So I do believe there is a beginning of a groundswell of support for this, and we have to just advance it with the sense of urgency that it warrants.
David Crane.
Thank you. Fascinating discussion. And, but, you know, we have to understand that how to get it done. You know, the bright red thread, and I've said this probably to all of you too many times, the bright red thread of modern international criminal law, atrocity accountability, is politics with a small p. It's a political decision to do things, establish justice mechanisms, hand over individuals for a fair trial. That's just part and parcel. And the discussion here just now, it's just part and parcel of making it happen. And it can be done. That's the key. We've done this before. It can be done. But there was also another little sidebar of that question is, well, who? Well, I just want to make a point is we have a very, looking at a basketball analogy, we have a deep bench. We have an incredible number of experienced prosecutors, registrars, judges from around the world who could step forward almost immediately and start working on this special tribunal relating to aggression, and working with their Ukrainian partners. You know, this is something that we've done before. So I just want to make that point that we don't have to reinvent the wheel here. Yes, it's very political, but I certainly agree that in some ways it's almost like if you build it, they will come in some sense. So, you know, I just wanted to make that those two small points.
Thank you. And Ambassador Hans-Karel.
Thank you. Just let me say that I agree entirely with what David Scheffer said here. I think it's very important to have this input from him. And also what Erwin Kotler and David Crane said also, I agree here. I would like to add a completely different element here. We are talking about raising, shall we say, support for this international tribunal and so forth. But there are many elements here. And one element that I have looked at is the following. I must stress that the Russians who are being recruited to the army are in impossible situation. Not only do they risk their lives on the battlefield in Ukraine, they also risk being ordered to commit war crimes for which they may be prosecuted after the war is over. And I think this is an important element. And I can understand why so many men are leaving the country now, because they don't want to get into this impossible situation. And I think that is an important element. And the question is to, shall we say, instill support and see to it that we can make people change their mind, particularly in Russia, that we will have a different way out of this than in the battlefield. Thank you.
Thank you. And I have one more difficult question for the panelists. And that is, David Crane alluded to this earlier, this issue of selective justice. How do you get around this argument that we're talking about creating an aggression tribunal just for Ukraine, but we don't really care about all the other places in the world where the kind of aggression maybe was committed in the past or is being committed now or might be committed in the future. So how do you get around that argument of selective justice? I have Jennifer to start, and then if anybody else wants to weigh in, please raise your hands.
Yeah, it's a great question. Our goal must always be justice across the boards. And we're rarely able to achieve that. So I'll quote our dear friend Brenda Hollis when I asked her this question on a panel. And she said, if 5 individuals commit felony murder and you can only apprehend 2, do you let those 2 go because you're missing the other 3? So we want justice to apply across the boards. And that is why in the long run, we need an amendment of the Kampala Amendment's jurisdictional regime. It was intended that this crime be at the International Criminal Court. It was intended that states parties to the court would be subject to the jurisdiction, and then potentially even more broadly, if nationals of non-state parties committed the crime and were in the territory of a state party, et cetera. And then the jurisdiction that we wanted didn't happen. So I do think we need to go back to the drawing board on the Kampala crime of aggression jurisdictional regime. A review is slated in 2025 on that. To do anything at the UN in 2025, you actually need to have begun that process actually yesterday. And it will be important to convene some kind of intersessional process leading into that, so we can seriously make headway on this topic in 2025 and make sure we don't need ad hoc tribunals, that the crime is at the ICC as was always intended. In the interval, I actually think an ad hoc tribunal actually can advance even what the ICC is intending to do, because it could show, yes, this crime can be prosecuted. And it will give us the template, yes, we can prosecute this crime at the International Criminal Court, and maybe make states more comfortable with that process so we can get the jurisdictional regime that we intended to have, so that it is not such a limited regime compared to the jurisdiction for genocide, war crimes, crimes against humanity. So I think ad hoc now, but in the long arc of things, it should be back at the International Criminal Court, that we don't need ad hoc solutions.
Thank you. Anybody else on this point? David?
I'm asked, not frequently, but Iraq comes up in our discussions. It's kind of like the 400-pound gorilla in the room. And the question always is, well, why didn't we do anything about the United States' actions related to Iraq? In response to, well, why should we have a special tribunal for aggression for Ukraine? And, my response is, and this has been, being asked to me live by BBC, et cetera. And I said, we can't look to the past for solutions and justifications. We have to look forward to what we're faced now. So that, and Brenda Hollis had it right exactly the same way. It's kind of what I was saying too, is that we can't use what happened in Iraq as an excuse for not doing anything against the Russian Federation. That is a terrible way to face atrocity crimes, particularly the crime of aggression around the world. So that's a point I'd like to make.
Thank you. And I see that Ambassador Correll has his hand up as well.
Thank you very much. I agree entirely with David Crane here. And what it all is all about is actually to establish the rule of law at the national and international level. And an important element in the rule of law is criminal justice. And we have to look forward. We have to create a world where people can live in dignity with their human rights protected. And Kofi Annan, whom I respected very much when I was his legal counsel for 7 years, and then later when we worked together for Kenya, he was not a lawyer, but he understood better than many lawyers that the rule of law is a precondition for international peace and security. So we have to work in this direction, and we can't just look back and see what we didn't do then and didn't do then. What we should say is we shouldn't make these mistakes again. We should go forward. Thank you.
And I see that Erwin Cutler also has his hand up.
Yeah, when we speak of selective justice, I think it's the other way around. It's that if we don't act on this, we will have no standing to act on anything else. If we don't act in the face of the most serious frontal assault on what we like to call the rules-based international order, which includes the crime of aggression, which includes breaches of the Genocide Convention, which includes horrific mass atrocity crimes, which includes massive domestic repression, the whole amidst an ongoing culture of impunity. If we don't act now, we will not have any standing to be able to act anywhere else. So I see this as principle and precedent for universal justice rather than the exercise of selective justice.
Thank you. Now, one last issue that I will just briefly mention, and maybe we can just take a quick minute to just address this, is the issue of compensation. We're talking about establishing a special tribunal for aggression, but what about compensation issues? My understanding from talking to our Ukrainian counterparts is the issue of compensation has been separated from the issue of aggression, and that there are some plans to create a compensation mechanism. But do any of you have thoughts on compensation, whether there ought to be some type of an international mechanism, some kind of an international, claims tribunal to address compensation issues? David Schaffer.
Yeah, just quickly, I would say that really has become an issue that is almost on par with individual criminal accountability, and for good reason. Ukraine needs to be rebuilt at an enormous scale. Where does that money come from? I've seen proposals for reparations and thus sort of compensatory schemes. And there's great difficulty with those proposals because one has to speak about seizing assets, whether it be of oligarchs or of the Russian government, et cetera, of insisting on negotiations that leverage whatever we can with Russia to burden them too and their people with the payment of reparations to Ukraine. And one can easily argue that's justified. But the point is, it does create an enormous burden on the international community, quite frankly, not only on Russia, but also on everyone else to pay this bill to rebuild Ukraine, and Ukraine must be rebuilt. I would simply argue that there could be some, some leverage on Russia in this respect, in that sanctions, or at least some body of sanctions against Russia, would not be lifted until they reach an agreement with the government of Ukraine on reparations. Those would be extremely difficult negotiations, but I would not argue that Ukraine give away all of its leverage without the issue of reparations being addressed. Remember, reparations will not really be an issue for the Special Tribunal against aggression, because that'll be against individuals. Some of them may have assets, like if any oligarchs are indicted, they may have assets that can be useful. But this is really a state responsibility issue, and it's going to be in a different forum where it is to be considered. Let me just I just put this in as a footnote very quickly. I have a large report coming out of the U.S. Holocaust Memorial Museum shortly on how we can tap the social bond market to assist victims of atrocity crimes, to help repair their lives and rebuild their lives and their communities. And I do think that Ukraine is going to be an interesting possibility with respect to a social bond, which I won't go into right now, that can raise a lot of money very, very quickly in the markets to deal with the needs of Ukraine. But it is going to require, a buy-in by governments as guarantor governments, et cetera, to make something like that happen. It's similar to what social bonds did during the pandemic. The European Union bought into them very, very big time in order to deal with the economic distress of the pandemic. And that's when the social bond market really took off. The bill, for Ukraine is enormous. And so we need to be looking at solutions like that, I think.
David.
I would just caution, let's not link two very important topics together. They need to be dealt with separately. Compensation is very, very important and needs to be addressed separately, but not try to set something up concurrently with the special tribunal. It would just get bogged down in too many issues. I think the creation of the special tribunal is a lot cleaner as far as creating it than really the sticky wicket of developing a fair and open compensation system. So I would just caution, please don't link the two very important topics together.
Ambassador Correll or Erwin or Jennifer, any closing thoughts?
No, I just agree with what David Crane just said, that we have to be very careful here. But my closing remark would be that I think it's important, the questions that we have discussed in this conference, and let us hope that there is support enough in the General Assembly for a resolution of the kind that David Crane, Arvin Kotler and I have proposed. And I hope that we have the support of as many states as possible. And it is interesting to see that when the United Nations General Assembly is now meeting on Ukraine under the Uniting for Peace system, there have been 3 resolutions here adopted. The first one on the 2nd of March, there were 141 votes in favor. The second later in March was 140 in favor. And the latest resolution condemning the annexation of the regions in Ukraine, I think there were 143 states voting in favor. If we have a number of that kind supporting the idea, I think it is very, very solid support. Maybe we will have even more, but it's difficult to say. But my hope is that the members of the United Nations will realize that we cannot allow a permanent member of the Security Council to violate in this way the most fundamental obligations in the UN Charter, obligation which the Security Council is set to supervise. Thank you.
Thank you. And I see David Sheffer, you have your hand up. Would you like
just to clarify, I hope there wasn't a misunderstanding. That was exactly the point I was trying to make, that these are 2 separate challenges. One is individual criminal responsibility and the other is reparations. I just think reparations is an elephant in the room right now because it is really, really the financial requirements of Ukraine are enormous. So there's got to be a body of people working on that issue, and then a body of people working on individual criminal responsibility. They're two very separate endeavors, but in all of my discussions on Ukraine, the reparations issue always comes up. And so it is something that we have to pay attention to as a state responsibility issue.
Thank you. Erwin Cutler.
Yeah, I agree with David Sheffer, and then I think when you speak with the Ukrainian interlocutors, both these objectives come up in the Berlin conference that I mentioned this morning. That's exactly what happened. But I think we've got to, while we pursue both tracks, we have to do so separately and work on the special tribunal as a matter of urgency, and where the framework is there for that purpose. I might add just parenthetically that the Canadian Parliament legislation has now been introduced with respect to the repurposing of assets and purposes of reparations. And I've been invited to join a group that has been established as we are speaking by the New Lines Institute to establish an international claims commission. I've looked at the white paper on that, and that'll clearly take more time. And we have to move on the international criminal, the tribunal for the crime of aggression, as I said, with a sense of urgency and all deliberate speed. At times such as these, if I may borrow a French motto, qui s'excuse, s'accuse, that whoever remains indifferent indicts himself or herself.
Hear, hear.
Thank you. We're out of time. I know that there's still many outstanding issues that we did not get to. I'll just mention one, which is the issue of potentially expelling the Russian Federation from the United Nations and trying to get around thereby the Security Council veto, but we'll have to leave that one to the next panel. Thank you again to the Global Accountability Network, the Ukrainian Bar Association, and the New York State Bar Association International Law Section for putting this together. Thank you to our amazing panelists, and thank you to all our audience members for being here with us today. Have a wonderful rest of the day, and I hope to see you at a future event.
Thank you.